Adam, why should I bother mediating a surrogate's court case? My parent, my grandparent, my other relative, their estate documents are clear. I clearly have the law on my side. We're going to win. We don't need to mediate this. Hi, I'm Adam Halper. I'm a mediator, collaborative attorney, and I'm a parenting coordinator. And today I just wanted to shift gears a little bit and talk about, mediating in surrogates court. Those of you who don't know, surrogates court is very often the place that people go to when after somebody has passed and they need to probate a will or dissolve a trust or in some other way take care of somebody's estate. Litigation in surrogates court is extremely complicated because the law surrounding people's passing and their estates and taxes and all of the things that are related to that are extremely complicated. Nevertheless, it's a place where people take on so much anger, so much grief. Someone has just passed. There's all kinds of feelings always attached to those moments, no matter who it was. And so here are just a couple of considerations that I wanted to talk about why you might want to consider mediating in surrogates court matter if you find yourself there. First, very often, the situation between the time that someone does their estate planning documents and their passing changes. What's an interesting example? They got married to somebody who nobody knew about. It happens more often than you think. It comes as a great shock to adult children and others. But needless to say, it's an area where suddenly what they had done in their estate planning documents and the facts on the ground are remarkably different. And litigating all of that and fighting over it is something you want to consider very carefully. And maybe the better considered approach is to see if a discussion can be had. Number two, the documents, estate planning documents, no matter how well they're done, and I have some real experience with this, they don't always tell the entire story. Some people do all kinds of advanced estate planning documents, wills, advanced directives, trusts of various kinds, but they may not tell the entire story of that moment. Anything can be litigated. And unfortunately, in this moment, the best source of what actually happened when the documents were being executed, well, that's gone. The person themselves who executed those documents is no longer around. So proving whatever it is you feel like you need to prove might be more difficult than you think. And the last point is something I really wanted to leave all of you with, which is this. Surrogates court and litigating in surrogates court very often comes down to money and whether or not you want to throw away an entire piece of your family over money. Very often, it's not nearly as much as you think it is. And over the course of a lifetime, over the course of your entire family history, let's say just for example, to throw away a sibling and dissolve your relationship with a sibling for $150,000, $200,000, whatever it may be. I'm not saying that's not a lot of money. It is, but is it worth your brother or your sister? Just something to think about. I'm Adam Halper. Thanks for tuning in. See you next time.